like it's a pretty cogent motion to me, but, get me off the ledge.
Well, listen, I can't wait to see her at my next, American Bar Association lunch. Me and Lori Vallow talking about the law. But what I will tell you, she makes some points. She cites the correct law. The criminal defendants have a right under state and constitutional law to a speedy trial. She's right about the times. What she doesn't seem to get, and by the way, she made this same argument, or her lawyers made this same argument out in Idaho, is that, yes, while she's entitled to a speedy trial and she didn't waive it, there are things that could delay it, as long as they're good cause. You know what happened? This case was delayed because she was just declared competent last month. Seems like that has been completely ignored. Competency, trials being moved, that can all delay the window. And so she says, I haven't been gone to trial since I was arraigned, yet she seems to ignore what is a key factor in this case. And by the way, I don't know necessarily what the rush is to go to trial. First of all, the evidence against her is really bad. She's already in life in prison, and I don't really know what her defense is going to be. And by the way, I have to tell you, I think it's pretty interesting, it's pretty rich that she takes issue with, why am I not being tried together at the same time with both of these crimes? Most defense attorneys would say that the charge that she's facing with respect to that relative, keep that out of this trial with respect to Charles Vallow. If the jury hears that evidence, it might prejudice them. Well, that should be a whole separate case. So I give her credit for filing this motion. I just don't think it's going to have any legs.
Also, it's more fun if you have another trial that you can use as a field trip, because it is very, very boring to spend your life behind bars in Idaho, I'm told. I do have to ask you this, the competency thing, because I think a lot of people read along with us, and they think that doesn't sound like somebody who only a few months ago was incompetent to stand trial, which means, technically, you don't understand the charges against you and you cannot help in your own defense. Those are the two prongs of competency. This lady sounds like there is no issue with competency at all. So is it that easy? And does the law recognize that you can flip in and out of competency on that severe of a scale?
Yeah, it can get really quite complicated. And by the way, going into Lori Vallow's mind is not a place that I think any of us want to be. But yes, it can flip. And when we say that, we're not talking about insanity, right? We're not talking about, did she appreciate the wrongfulness of a crime? It's, can she appreciate the charges? Can she meaningfully help in her defense? And sometimes that can change. It may take months, it may take weeks. There's really no hardline test, but she had been evaluated by psychologists and they determined that she was competent to stand trial. Doesn't mean she knows the law, doesn't mean she's going to present a strong case, doesn't really mean she knows what she's doing. And by the way, even though she's representing herself, she doesn't get any leeway. She still has to follow the rules of evidence. She has to make the appropriate objections. She has to make sure she follows the court rules. So again, this is a really bad decision on her point. But like you said, a lot of criminal defendants are already facing the rest of their life in prison. This is exciting. This is a timeout. This is a new opportunity to tell a story and be in a courtroom. It's a change of pace for what she's going to be facing for the rest of her life.
Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.